All
And we're
right,
live.
here we go. Hi, this is Curt Verone,
And Brad Pinsky.
and we are here for a crazy edition of Fire Law Roundup for February 10th of 2025. And I am coming to you from Indianapolis. And we had a crazy day. I've been pretty much going without sleep for 48 hours here. So if I'm babbling, I'll attribute it to that as opposed to anything else. So, but my flights got canceled. We're here for our FLSA class, and the flights got canceled. And we said, well, we've got 100 people waiting, so we're going to drive. And uh, 16 hours or so later, we
Oh,
pulled in here at about 2 o'clock in the morning and slept for 3 hours, and we're up trying to take batting practice. So
the crazy life of Curt Verone.
yeah, it shouldn't be this way, right? It should be getting easier, right? But
Right. Okay. Well, we have, look, we have 5 cases and hopefully one other issue we could talk about on
yep.
FMLA. But the 5 cases you posted this week, 3 of them are great because they're lessons learned in the sense of what's the difference between these three. So there are 3 race discrimination cases, but they all three. The third one, we'll go out a little out of order. I think if people are like, "Hey, I want to," let's say it this way: in law school, we learn a case, and then you're given another case, and then you're given
Mhm.
another case, and the professor always says, "What's the difference? Why the different holdings between the 3 cases?" So these are really 3 good, important discrimination cases, and they work out perfectly as if you crafted right the release of them to match the timing. So let's start in Nashville. We have a
Just
fire.
for clarity, just I don't have the creativity to do that. So it's just pure coincidence.
It worked out perfectly. So in Nashville, we have a fire captain who was demoted over a social media post. Right now, let's go back for the viewers. It's basically a 2, or if you listen, some people a 3-prong question test, but it's a Pickering test, and it asked whether a person was when speaking, right, or writing, or expressing an opinion in this case, whether they were speaking as a private citizen, which in case they would presumably have a First Amendment right, or were they speaking as an employee, which most of their speech would not be protected, and then
Yep.
whether they're speaking on a matter of public concern.
Mhm.
But here we have the former captain, and he's awarded. So be careful about what you do here. $1.8 million, right, by a federal court for his violation of his First Amendment rights. So that should get everyone's attention to be like, we should be really careful what we do to our people. So he claimed he was investigated and ultimately demoted because he offended someone in the African American community. And so he's basically saying he was retaliated against based on his speech. And he said, okay, he's demoted because he made political comments regarding certain issues. For example, Black Lives Matter, which we saw a ton of during the George Floyd and all that.
Mhm.
COVID-19 mask mandate, which we saw a ton of comments, and global warming. And he
Mhm.
made comments, and the employer, I presume, didn't like it, and allegedly retaliated against him for making private comments. So clearly, we're not going to get into the whole Pickering point for here because this serves a different purpose, but the court already held his First Amendment rights are protected. And 2 important lines you quote. He said, this is an important vindication, this is from the lawyer, of public employees' freedom to exercise their right to free speech, and we should never tolerate government retaliation against an employee for speaking out on matters which are inherent to public concern. Again, that's the lawyer speaking, not the court. But
Mhm.
the point is still correct, right? Public employers better be real careful when they comment on somebody just because the speech looks not it's not discriminatory, right? It expresses maybe an unpopular view, but it's not hate speech.
Yeah, this is a really tough area, and finding the balance between both sides is really, really difficult in these polarized environments. And I do wonder if 20 years from now we look back at these things and kind of laugh at them. But I think we're struggling with a lot of these issues today. And you have people on both sides of the social spectrum making their points, which they see their friends who are not in government making their points in social media, and they want to share those thoughts. And where the line is tough. And I think I kind of center in on that. Hate speech, which the Supreme Court is not, they don't like that term,
No,
but
because they
at the
say
same
hate
time,
speech isn't speech.
right. The way that they really characterize it is, even if you're speaking on a matter of public concern, even if you do it as a private citizen, you're not engaged in speech that could cause harm to the mission and function of the organization. Okay, so if the mission and function of the fire service is to provide services to everyone, then you cannot engage in speech that would cause actual harm or disruption to the mission and function of the fire department. I know that sounds like a lot of word salad there, fancy word salad, but it's word salad. But essentially, when you engage in speech that could compromise the ability of the organization to carry out its mission, in other words, that people may say, I don't feel comfortable calling the fire department because I don't want that person coming to my house. And so there's an awful lot of speculation and ambiguity inherent in what I just said.
And there's the disruptive within the organization exception that this could
that
also.
too. But when somebody says something that I agree with, it's very difficult for me to say, oh, that could be disruptive. And when somebody says something that I disagree with, it's very easy for me to say, oh, that would be disruptive. And that's our index card that we've talked about. So it's a challenge. And I don't mean to trivialize the challenge. Nashville's had cases on both sides of this spectrum. And they struggle with it like a lot of other metro departments. Not all departments that have struggled with this issue have become front page news like Nashville has, unfortunately. Okay. And this shouldn't in any way reflect negatively on Nashville. They are struggling with this just like every other fire department is struggling with it. And unfortunately, they got hit for 1.8 million. The jury felt like they didn't strike the balance properly. Okay, they've got other cases on the other side of the same issue from the other perspective. And, we'll see how those cases come out as well. In fact, I think one of the cases already come out in the city's favor. So
right.
it's tough to be even-handed. We've seen it in so many different departments.
It is. And it's there. Some of these are what we call law bright line tests, right? It's something is so close. Now, hate speech has a definition.
Yep.
Hate speech is not just speech that's hateful, but it's speech that's designed to place someone in the threat, the fear of imminent harm. So hate speech is like you're burning a cross on someone's lawn, right? That would be hate speech, even though it's not speech, but it's hate speech. Whereas you just say something like, well, I, certain people offend me of a certain color, or I don't, right? I mean, that's very different. You're not placing anyone in fear of imminent harm. But so, our point to call your attorney right before you do something like this.
Oh yeah, you've got to, and I think that we've been able to, through looking at it the way I've been looking at it, we've been able to kind of categorize some of the areas that kind of cross the line into actual harm or disruption. Threatening or encouraging others to engage in some sort of violence or anything of that nature. Run people. We're gonna if the protesters come in front of me, I'm gonna run them over. We should run them over. We should teach them a lesson. That's threatening harm. That's going to be over the line. The other is threatening or encouraging others to withhold services to certain people.
Yeah.
Okay. Or suggesting that we're going to go slow to that neighborhood, or if that council person doesn't like the fire department, see how long it takes us to get to their house, or that, those types of things. That's crossing the line. Okay. Saying that you disagree with a certain position, is protected. Saying that I believe in a certain position is generally protected. But when there's that crossover into causing actual harm, and it's not clear. Again, it's this. I hate to use the word salad, but you start to get into some of this, and lawyers and judges convince ourselves that we're being precise, and we're making it difficult for non-attorneys to really draw the line in future cases. So.
Right.
Enough said.
Yep. Okay. Now let's stay on this topic, a little different, right? But for the second case, we're going to go to Washington State. We have a recruit who was learning knots, doesn't tie, they tie a pressic knot, which everybody who does rope rescue, we know what that's for. It's the break kind of on a rope. But it doesn't look like a noose, except there's those two, the two wraps and double wrap back that kind of connect. When you put them together, it kind of does look like a noose, except that a pressic's a circle. So, there's no other line. In any event, a recruit firefighter once took and I'm saying these words importantly, right? Once took the noose or took the rope and made it look like a noose, put it on an African-American I think probationary firefighter's neck. That was it. Now, I don't say that was it, meaning, oh, that's no big deal. That was all they did, a one-time act. And what happens is they sue the department, right? But ultimately what happens is the court, in a very good ruling, says, wait a minute, one time isn't enough. One time isn't enough. So what happens, practically speaking, which is fun to see, but I want to go back to the one time isn't enough rule, but the trial court dismisses all the federal charges against everybody except the firefighter who put the alleged noose over his head. He was going to appeal. But what the court did, in a very interesting way of twisting the knife in the guy, saying, cut it out, is they bill him. Basically, the court says, you owe the defendant $20,000, court costs, fees, etc., which is not overly common in my experience.
And that's not a lot either.
Not a lot.
But
it is if you're one individual, right? And because he would have to pay it. The plaintiff, the person suing who lost, would have to pay it. So what happens is it always serves a good purpose to say, okay, if you discontinue this lawsuit, which you already lost anyway, we'll let you off the hook for the money. And they ultimately did. But the court decision is more important, because what the court says is the one-time actions of a probationary coworker do not constitute an adverse employment action by the employer. Now, there's a lot of very important points to this, so nobody should take this too far to the extreme. One-time act is important, but if this was the boss, if this was a captain, a chief, this would not apply.
Yeah,
right?
That's a great point. Yeah,
right.
If this was any of the instructors, this
right.
would not apply. But what we're talking about is, I guess the issue here to me is, at what point can worker A's conduct to worker B create liability, not for worker A, but for the employer?
And the answer is easy. When the employer has knowledge or should have had knowledge. And like we have in sexual harassment cases, when it's a manager or supervisor who does the harassing, you lose automatically. You're deemed to know. You're the employer. You can't harass your people and say, but it was only once, right? But here, it's the best of all facts. Probationary firefighter, not long on the job, not even permanently on the job. And by the way, they fire him. So they didn't tolerate it.
Very quickly, they suspended him that day. He was out of the workplace and he was gone in 2 days. So, and I think that, I really think that sends an important message to the court. It sends a subliminal message that we're taking it seriously. Flipping around, what if they let this guy stay on? And maybe he did something else. Maybe 2 or 3 months into the academy, now he does something else. There's the possibility of an allegation that they condone the behavior.
Yeah, and that's the issue. Did you condone it, or did you maybe pull them aside and say, listen, do you understand, we're going to offer you training and counseling and make clear that that's not acceptable, right? That would be good. But your point is very well taken and very important for people to understand. When you have a harassment allegation, I don't care if you find it valid or not. I don't care if it's sexual harassment, any harassment. When you have an harassment allegation, 2 things always happen, and you will win in many cases if you do these 2 things. One, you conduct a full and fair investigation, not with the department's attorney or whatever, right? But you do a full and fair neutral investigation, number 1. And 2, regardless of what the findings are, harassment, not harassment, valid, not valid complaint, you offer training to either everybody or the people involved. And those 2 things get you out of a lot. And I just actually raised that to OSHA for a client who's alleged, I won't get into this, but who's alleged to have done something. And I said, look, regardless of whether you, Department of Labor and OSHA, think there's a violation, we didn't. But regardless, we investigated and trained. What more could we do other than discipline an actor? But we trained the actor, right, to not do it again, which is counseling, kind of like discipline. So for that reason, if in most cases that ends it.
Yeah.
Right.
It should.
Anyway, okay.
It should, but this is an example of handling it properly. I think it's a really good example. Change the facts a little bit, make it an instructor, have the department not promptly investigate it, not promptly discipline, not promptly attend to it. We've got a different situation, have several others. And, I do think there's also, hello.
Yeah, I'm sorry. People are walking around the back of me.
Oh,
you're not going to want to do that. You're going to be on video.
Well, you can't make this stuff up. Here we go.
No, you can't. And that's the live show. It just happens. So now let's go to Florida, where if anyone is confused, that palm tree behind me is real, as are the people. But now we've done those two cases. And now for the law school purpose of it, for the educational purpose, I invite all the viewers to kind of question, right? Run the question, run this as now what have we learned? So here's what we got. We have a dispatcher. Now, this is a lawsuit, not a court decision, so we don't know how it comes out. But now we have the first two cases. People can analyze how this should turn out, and we'll do that. So we have a dispatcher who's with the Florida Fire Department. She's filed suit claiming she was forced to resign in 23 due to a racially hostile workplace situation. And so here's what she says. She does this under Title VII, the normal. She worked for a defendant as a 911 operator since 22. She claims she was constructively terminated, meaning it got so bad she had to leave. And I urge people, file a lawsuit before you resign. It just, in the real world, it looks better too. But in any event, the plaintiff is a Black female, and she said that she's overheard two male white Caucasian coworkers discussing Joe Biden and the president's plan for student loan forgiveness, right? As we recall. And there was a news segment on it. And what they said was they are always looking for handouts, just like government assistance, food stamps, and shit. They should just get off their lazy beep and work. So let's stop there. So we have somebody overhearing it. It's not being said to her, right? Just like on social media, you're not saying anything. I find this portion of the case very much like the first, and they're expressing an opinion. However, they also take that opinion and show why they have that opinion based on some stereotypes or biases or maybe untrue statements. Now, I don't know who they is, right? Which matters. They could be white people, right? But if we stopped the case here, and by the way, we don't think these are managerial people. It's just two coworkers, right? But it's two coworkers. Stop here for a second. There's no allegation yet that anybody else knew of this. She doesn't say, I reported this specific conduct. And this was up till this moment, was a one-time thing. If we stopped here, I think we would agree, based on the first two cases, no liability.
Agree. Yeah, right? I would agree.
And the question I have is, they're not really, if we took this under Pickering, are they speaking as an employee? It's hard to imagine they are. It's not part of their job. And they're talking about things that have nothing to do with the job, right? Student loan forgiveness. So to me, this would be protected speech, and it clearly is a matter of public concern what their comments were. It's just the hateful follow-up.
Yeah, it kind of gets to, like you said, the Nashville case, kind of moving us over there. And what sort, and Nashville wasn't necessarily in the workplace conversations, but at what point are people free to sort of share their political views in the workplace, and go ahead and try to have a rule that says you can't talk politics in the workplace. Good.
Yeah. You can have the rule all you want.
Yeah. What's the difference between you start to get into just daily conversations and you edge into politics. So really, really difficult. But and this one, when I lecture on to officers on this is where we say officers have got to have a good handle on their people and avoid these kinds of things from escalating into a knockdown, drag out on politics, because
Yep.
you might start out talking about the Super Bowl, and the next thing you know, you're in here talking about an issue like this, and it's
True.
we need the officers to kind of manage that for us.
But I think we would agree at this point, and there's one other important fact. At this point, there would be no loss if that was the only fact.
Yeah.
And she says, I understood that they meant are the African American or Black community, and
Yeah.
I don't
She
that
may
would
be
not
right.
hold up.
Probably right.
Right?
I'm sorry.
She may be right, but
Oh yeah, it's still not enough. It's still
okay.
not enough. Right.
Okay, so then let's.
That when I lecture on this for officers, I do a couple of different classes on officers, but I talk about HR lawsuits as thinking about like dominoes, okay? And if we're talking about an apparatus accident, one domino falls. You get in an accident, there's probably going to be a lawsuit. You have a line of duty death at a structure fire, one domino falls, we're going to have a lawsuit. HR, it's not like that. It's a series of dominoes. It's a series of comments, a series of statements, series of pranks, series of things. And these are each warning signs for our officers to intervene, that I need to intervene. You got to be watching for all these dominoes. And look at all the dominoes that are in this case before she ultimately does what she does.
Right. So that's November of 22, instance number 1. But noticeably absent, she doesn't say she told anything to her supervisors. And I'm not criticizing her, because why would you the first time you hear it? Okay, dumb people make stupid comments. Okay, but
and by the way, she had only been on the job a month when this happened. So she was relatively new.
Right. But again, it wasn't said to her, right? She's overhearing comments in the workplace, which for harassment is a big deal. Okay. But now, building on this dominoes, right? The second domino to fall in January of 23, so 2 or 3 months later, another white male who's a coworker of her was talking about the Hamlin Buffalo Bills CPR heart attack, which they honored on the Super Bowl last night. We watched, and they said, allegedly, right? I bet it comes out that the thug was using drugs. That didn't look like he was hit hard enough to collapse. Okay. It's a little easier to tie this to the fact that he was Black, because they're talking now about a specific individual.
Right.
We still don't have it said to her. It's just the environment now is starting to become toxic.
Yeah.
Right.
But again, at one point here, again, we're talking about A, saying something or doing something that impacts B, that somehow creates liability, not for A or B, creates liability for the employer. And I think that's really what we want to, because is in each of these instances, is what A said inappropriate? Yes, we all agree, shouldn't have said it, doesn't belong in the workplace, totally inappropriate. But at what point does that create liability for the employer?
And in the first case, with the Noose case, we say it's a one-time act, right? And they immediately reacted to it because they knew it. They observed it or was reported to them. Here, so far, now we have 2 acts, but neither time does the employer know. And these aren't managers or supervisors. So if she sued on the first and second act, I think she would lose, right?
Yeah, I agree.
Now we have reports of a GoFundMe for Hamlin, and they continue that. I'm not going to read all of it verbatim because YouTube will ban us, but they say, why the F are they raising money for him? He should be rich already, but he's probably broke from buying cars with big rims, women, and houses. Now, the only part of that I find discriminatory is a reference to big rims, but that's not so.
Well,
I don't find that discriminatory.
There's a stereotype there. And this kid, but Hamlin's a great kid. I mean, he's a really good person.
Right.
I don't know.
But the women and houses comment isn't.
There's a stereotype there. There's a stereotype there, I think. But go ahead.
No, but your and my differing opinion is right. That's where we're starting being on the line. I'm not saying it's a proper comment, but
no. But I feel confident I could tie that to racism.
And if I'm their lawyer, I'm saying he's just talking about football players, white, black, green, yellow, doesn't matter. He's just stereotyping football players, right? But because he just made a comment about Hamlin that's clearly tied to race. So, okay. But now we have, that's the kind of the second and a half third. And then we have February of 23, right? We're still right there within a 3-4 month period. This new worker is now, this is what she's seeing as her environment. Her co-worker's office offers what she claims are racial observations concerning Black History Month. And this one, I got to tell you, for our viewers, this is like the city of Rochester, where they brought the black firefighter, the captain drove the engine to this alleged party, right, that making fun of Juneteenth that we covered about a year ago, I think. So they're making comments about watermelon or Black people's food. And here now change everything. They asked plaintiff if she eats chicken and waffles. Now we have harassment. Direct. And by the way, this is a lawsuit, not a finding. So these are allegations, right, to the viewers. But this is the first time they're not just in proximity to her, they are allegedly dead on harassment based on race.
And to me, the way I kind of explain it, this would be a big domino. Like there's little dominoes, there's all dominoes, but this is a big one. And when this one falls, it has the potential to kind of move us closer toward a lawsuit.
Right. I would call that the cake, and everything that happens next, which built the recipe for the liability cake, is now the icing on the cake as far as this individual is concerned. So we have a couple of more issues. We have now another occasion. The plaintiff hears a white female refer to a Black coworker as the N-word. Now there's no way that's just hate speech, dead, right? I mean, well, it's hateful speech. It may not be hate speech, but it's hateful speech. In any event, now she reports it. So now the employer comes in because there's no question that they're aware. The question later would have been, was it so permeating the environment? I think is the test that they should have been aware had they just opened their eyes. Here, now we have direct knowledge, right? So we have the plaintiff hearing the supervisors and the managers talk about sticking together, making sure all their stories and emails line up. And this happened right after she reported racism to the employer, or these instances to the employer. And then they're saying, okay, as a result, let's get our line together. Let's cover this up. And finally, what always happens, right, is we have her, she feels like she's being discriminated, harassed, and retaliated against a little bit. And she said the bullying and the racial harassment became so bad. And now she's using a new phrase, bullying, which seems that's personal. Bully is personal. Discrimination is not necessarily, right? But bullying is personal. I don't know where that is here. We kind of missed the bullying allegations. Unless
I can't possibly put all of the factual allegations.
Understood.
I read up, so some of it may be in the complaint itself. Yeah.
Right. But you could see she makes a report, she's retaliated against, and she overhears them talking about getting their stories together. Here you go. And so she then resigns. She says it's constructive discharge. She couldn't stay there any longer. So she just resigns. And look, if this is proven true, and here's the problem, it's going to be very difficult to prove it true unless the employer was ethical and maintained actual records, or unless she has some recording or proof of, reporting this, because otherwise it's he said, she said. And if the employer was truly trying to cover it up, which you and I are not saying they were or they weren't, but there's going to be no record of this, or there's going to be, this is what you told us, we investigated, we couldn't validate it, right? That type of thing. But it's a fair lawsuit, but it's a very difficult proof.
I think so. Yeah, it would have been, if she had more of the dominoes that had fallen, it'd be an easier case. So I think she's got enough. I think, we could equate this to our McDonnell Douglas balancing, balance shifting. Yep. She's got enough now. She's got to put it on the department's side. The department's got to show a legitimate, non-discriminatory reason for her departure.
And she resigned. That's the hard part.
Yeah. Right.
That's the problem with resignations in McDonnell Douglas, where she's going to say, I had no choice.
If they are to show that they were getting ready to terminate her for incompetence or several things that they were prepared to, that may put a different wrinkle on some of her allegations. It may. I'm not saying it would.
Right.
But I think if this came into my office, I think we're looking at a monetary settlement, get this out of here. And
I would too. I would, I agree with you. Okay. So now let's let's jump to FDNY. And so if anyone has ever taken this is a little crazy. I hate offering this opinion, but Captain Morris is a legend.
Yeah, who is?
Captain Morris from Rescue One is a freaking legend.
Okay.
So if it's the same Rescue One Captain Morris I'm thinking of, I've taken courses from him on forcible entry and locks. He's a 9/11 legend. I thought he retired prior to 19, but maybe not. We could Google it. If it's the same Captain Morris, I can't imagine there are too many from Rescue One anyway. But Captain Morris is a legend, I'm telling you. But he was older when I took courses, and again, this guy was at 9/11. Again, if I'm got the facts right, anyone don't yell at me if I don't. But the Captain Morris from Rescue One I took classes from and know of. I did at FDIC. I did elevator rescue with him, and we were rappelling down the elevator shaft. And I mean, everyone's in awe. It's like, oh my God, it's Captain Morris, right? So with that, if I'm accurate background, these facts are a little strange. So the facts we have is we have an FDNY firefighter who I can make this really simple. He allegedly came to Captain Morris's defense when people were picking on him, which I'm not saying they did or didn't. I'm just, God, the guy's a legend. Who would ever, right? I mean, I don't know. Maybe we need Billy G or somebody to chime in on this, and he writes a letter in support of Captain Morris, and allegedly he then starts getting harassed and berated, and then he's given a choice to be voluntarily reassigned to Rescue 5. It's still Rescue, but in the world of Rescue 1 is, the golden goose for assignments. But nonetheless, it's still Rescue, which is also a very impressive, right? Everyone knows, for the FDNY. So he gets assigned there, and then he allegedly is told it's voluntary. Then he's told it's not voluntary. And then he's not brought back. I mean, he's basically saying they're retaliating against me because I supported Captain Morris.
You get into the weeds of this, and I'm stuck at, you got transferred and you filed a federal court lawsuit, which I don't know what you would require for a deposit or a retainer up front to take because of a transfer.
To a comparable job.
I mean, even if you're totally right, you're right. It's like somebody filing a lawsuit because I had this particular seat on the airplane and they made me sit on that particular seat on the airplane. You're going to file a federal court lawsuit over it? You were wronged. Okay, let's agree. You were wrong. But file a grievance, file whatever sort of civil service thing you want to do, but you're going to turn it into a federal case.
Yeah, I don't know. And I'm just, I got to spend some time on Google because I'm Captain Morris. I'm also going to do this when we speak about the next case. But I just can't believe that the FDNY would ever do anything bad to him. So anyway.
Again, you're on the weeds on that, and I'm still at the why are we in federal court? If I'm a federal court judge, I'm going to be really hard on his attorney. I'm going to be totally honest with you. You're tying up the federal resources over a transfer and a temporary assignment. And not that what happened to you was right. I'm not saying what they did to you was right.
Right.
I'm just saying this is federal court.
I know. They're just not going to care, right, about this. So I'm looking at when he retired. I think he retired in 13. So I'm a little confused. Yeah, he retired in 2013. Captain Robert Morris of Rescue 1. I don't know if it's the same one or not.
Yeah, I don't know. But again, I'm still stuck at the top here.
I know, I'm in the weeds. I'm in the weeds.
Why? Well, you're from New York and you've got so many friends and clients in FDNY, but I'm still like, what? it's just inconceivable to me that we're going to go to federal court
over this.
somebody being transferred.
From one rescue to another. Look, if you transfer
You're just
rescue to engine.
It's a detail. It's not even a transfer. It's a detail.
Right. Right. I agree. I agree. I don't understand any of it. Okay. So our fifth and final case is mine. And it's important, not for the reasons yet that have happened, but what we have is we have a lieutenant. This case is old. It's 2 years ago. We've been waiting for a court decision for a while. We finally got it. So we had a lieutenant who was suspended. He's a volunteer lieutenant with a volunteer department, and he was suspended, but he was never given any charges, or he was never given a hearing or any due process. And in New York, for a volunteer, General Municipal Law 209L requires that you get due process. And the court found you got none, so you're reinstated. And they voided his reinstatement. But the attorney, which is me, I got smart around that time when I filed the suit. I used to just file them and be like, okay, I wouldn't take it on a contingency fee because there's no big award for this. But I would normally say, well, this is how much it cost you, and I would accept money. And if we win, who knows? Maybe you get money back, maybe you don't. But since then, recently I've started filing these as 1983 actions, and they are violation of your constitutional state and federal due process rights. And it's what's called a hybrid action. It challenges the suspension and it challenges the due process violation. So I've got the win, right? Lieutenant Colleen won on your due process rights were violated, and you're hereby reinstated with a clean record. The court then says, now we're going to have a hearing on the next part. And the next part is the federal, right, deprivation of due process rights.
Brad, let me just, for everyone who's not from New York and isn't fully familiar with Article 78 action, that does not allow for attorney's fees. Is that correct? It does allow.
It does, but I've never seen them awarded.
Okay, so basically, you have three laws here. You've got your general municipal law. Was it 219?
209L, yeah.
209L that allows firefighters being disciplined to have a hearing. That is unlike any other state that I'm aware of for volunteers. You have those kind of rights for career firefighters, but not for volunteers. So you have the state law. Then in addition, you have this Article 78 that provides an avenue for people who are upset about the violation of 209. But even if you prevail under that, there's no way to recover damages.
Correct. Unless.
Now we go to the 1983 action.
Right. So for everybody who knows, 42 U.S. Code, right? It's a federal law, and there's 1981, 83, 84, right? All of them, but I only deal with 81 and 83, I guess. But we have this action which says your constitutional rights have been violated. Now, the New York State's highest, right? And the benefit is if there's a due process violation, then, and you win on it, then the attorney gets his fees. Now, the person hasn't won anything, right? Except the right to be represented and not owe the attorney $35,000, $45,000. These are expensive. I mean, we spent somewhere between $35,000 and $50,000 on this. I haven't looked at the bill recently, but these are expensive cases because they got a very big firm. The insurance got, I'll just say, a very big firm, and they throw everything at it, and they think no one's going to be able to afford it. So that's why this is so important. If the court doesn't recognize that the deprivation of the volunteer firefighters' due process rights justify the attorney to be paid, who's ever going to take this?
Yeah. I
mean, this is a big deal. The New York State's highest court has said, so I have a lot of hope, has said that even if the damages the individual gets are nominal, minimal, $1, $10, it doesn't matter. Because they prevailed on their federal rights or due process rights, their attorney gets paid. Like with FLSA, like with FMLA, like with a lot of other federal laws, that the money isn't worth the attorney time unless the attorney is going to get paid for the win.
Right.
So, and that's why I think this is a big deal case. I had won a similar case about 3 weeks before against the same law firm, same county, Suffolk County, Long Island, where they basically they've already held he was denied due process, but it's going to be the same thing. And it's just, it would be unfair. I turn down cases all the time where I'm like, your type of violation, I don't think I could recover under 1983. And so I'm not going to take it. And they're like, but I was wronged. I'm like, you were wronged. But you can't afford the $30, $40, $50,000. And that's routinely what this is. So I hope this works
I
out.
kind of look at and I think I kind of mentioned it in the article there, that if you don't win this, if you don't prevail on that part of it,
I'm out.
then what New York firefighters have a right that is really, it's a paper tiger, because nobody's going to, unless the firefighter is somehow going to go through the legal system pro se, they have no way to basically force the fire department to do things right, to follow that 209.
Right.
And if they don't follow 209, then, well, there's no consequence to it and they can get away with it. So,
and I want to say something, because I'm going to say this to the court too. I represent about 100 some odd fire districts in addition to departments. And I have said to my clients every time when they didn't follow proper due process, I said, do you think this person can really afford to sue? And I should, right? Because I'm representing the department of that issue. That's not proper.
Well, yes, it is. Yes, it is. Because, we're hired guns, let's face it. And we have to put our zealous representation hat on and point it in the direction that our clients needed to go in. And that sometimes can mean we're going to do things in a certain way when we're representing the fire department, and we're going to make the opposite arguments when we're representing the firefighter. And it's the way it is. It's just the way it is.
It's true.
No.
It's true. And money shouldn't be a factor.
Be an attorney, because that's part of being an attorney. That's why even in law school, they make you argue things you don't believe, because you have to be able to do that.
Yep.
Well,
that's true.
That's why people hate us. So that's one of the reasons why people hate us. But
yeah, they hate us when they lose to us, but then they always hire us when they need a lawyer. So I can't tell you how many past clients
I've gone up against some guys, and I like, and then a couple of months later, I get a case and I want to refer it to them. I say, you kicked my butt so bad.
Yeah, you deserve this.
Yeah, right. So,
I've done that. So I don't know for our viewers, but I don't know whether you want to take 5 minutes and talk about the last issue.
Yeah, let me kind of lay it out. We've got a hypothetical that came in, and I think it's really interesting. It has to do with the FMLA. And Brad has done some lecturing. We got to do another one of those FMLA.
We'll do another soon. Yeah.
Classes. But the Family Medical Leave Act. And the question is, and I think it can kind of go in a couple of different ways. So, but you basically have a firefighter who, let's say it's family related. It's got family related issues. And is seeking FMLA leave. Now, the situation is the department at the time has a shortage of firefighters, and there's a great deal of mandatory overtime. And so what the firefighter is looking for is, because of his the child that's ill or whatever it may be, can the firefighter use the FMLA to get time off, to basically saying, he's going to be exempt from mandatory overtime. So that's sort of one scenario. Kind of a closely related scenario is where somebody who's maybe got some PTSD or job-related stress, and the doctor has said, we can't, 40 hours a week is fine, or whatever it is, 53 hours a week is fine, but it's the overtime that's killing you, and we've got to knock you down. Okay, so can the FMLA be used to address this particular type of a situation?
And the answer to that,
I do want to separate a separate thing. I know I have been on the opposite side of this from management, and the management is, if our people can walk in with a doctor's note and get themselves out of mandatory overtime, which in turn now is going to burden brother and sister firefighters who did not go to a doctor, is that fair to our membership? Now, that is a separate issue, and we want to kind of be laser sharp in our distinctions here. The question is, does the FMLA prohibit it? Is it, or allow it? Is it not whether or not it's a good idea, not whether or not it's fair to other people? Because
Right.
I think there's some arguments that can be made. This is ridiculous to allow anybody to get out of that. But the question is really limited to the FMLA.
Right. So what the answer is, the law protects, and I'll be very specific, the law protects the employee, but it's going to be in vain if this is a ploy. So remember, you only get 12 weeks, right, of unpaid leave that can run concurrent with any other leave. It's not an additional 12 weeks. So if you get sick time, right, and you're using sick time, you don't then get an additional 12 weeks if your policy is written the right way to say it's concurrent. So this would be called intermittent leave. I can work the 40 or the 50, but I can't work more. That's intermittent leave. I can be here sometime and not other time. And intermittent leave is allowed with a whole bunch of other rules we won't get into. But the short answer is yes. If somebody has a doctor's note which says they cannot work the mandatory overtime, then one, that employer has to give them 12 weeks, right? Or the hours equivalent of 12 weeks. All this focus on so many policy issues, right? What's a week? What's an hour? All that. But because all weeks are not the same. Is it based on 52? It's based on 40? Different issue, different lecture that we do get into. However, when we do our, our 4-hour or 8-hour FMLA, but the employer has to give it, but there's only 12 weeks at most. And remember, maybe have they used other sick time? Do they have any left? Have they lost other vacation or whatever time that you ran concurrent? But you only get 12 weeks. So 12 weeks of how many hours? It's the week hour conversion. That's the tough part.
Right. Yeah.
The next thing, which I only recently learned, because as I was looking up, trying to give you a good case for this, another thing came to mind. And one of the courts has said, and this is not rare, it's not a one-off court decision, said, if being able to work mandatory overtime is an essential job requirement, then if the reason for the FMLA leave is due to a personal disability, not caring for somebody else, very different issue, the ADA could deem this individual's not qualified for the position. So if they always said, listen, 12 weeks a year isn't going to do it for me, I need never to work mandatory overtime, then if you've included that reasonably in your essential job performance requirements that you have to be physically able to work this overtime, and look, it's usually a mandatory subject of negotiation, right? We'll give you minimum staffing, but you got to give us mandatory overtime, whatever. So they're going to be basically disabled out of the job. Now, my last note on this, if it's voluntary overtime and they can't take it, different rules. The FMLA doesn't require you to work it, but you can't charge the employer for those, or the employee for those hours, right? You can't force them to use FMLA when it's voluntary overtime. That would be ridiculous. So that's the answer, but it's a really good question. And it goes back to, you better have good policies.
Yeah, absolutely. And I think it interconnects a little bit with the ADA, because particularly when you get into the PTSD, it also, when you're talking about work-related PTSD, it can also get into workers' comp, and what your workers' comp allows, what your workers' comp doesn't allow, and trying to accommodate time off as an accommodation. Time off can be used as an accommodation. Maximum hours can be used as an accommodation. And here's another aspect. I don't want to belabor it too much, but for those who've been through the FLSA program, you understand that the fire service has an artificial understanding of overtime, right? Yeah. And what I mean by that is, like, from the Department of Labor and Wage and Hour, the FLSA, hours are hours. And when your employer tells you to be someplace, that's hours. That's hours, okay? There's not designated hours that are straight time and designated hours that are overtime. It's just hours. And then once your week is complete, or once your work period is complete, then we look back at the hours that you worked and then calculate what you're eligible for that time and a half for, the overtime for, okay? And what I mean by that is, like, if I work at Home Depot and I'm scheduled on Monday, Wednesday, and Friday for, I don't know, 14 hours or whatever, and I come in on a Tuesday, that is not overtime. Okay.
Right.
It does not become overtime until I go over 40 hours in a week. Okay. So as firefighters, if I'm on A shift and I work on any shift other than A shift, I consider that to be overtime. That is not how wage and hour works for the rest of the world.
Right.
Hours are hours. Okay. And once you go over the magic number, then those hours, and point here being is that it could be your regularly scheduled shift that is actually your overtime that you work on. If you're on A
Right.
shift and maybe you work on B shift and you work on C shift, and then it's your A shift
That
that is
pushes you over.
actually putting you over the thing. So, and again, I think that complicates our understanding of it, particularly when it comes to things like mandatory overtime, because there really is no such thing as mandatory overtime when it comes to the FLSA. It's just you have to go to work. You have to go to work when, if I'm assigned to A shift, when A shift is working, I have to be there. And then if my boss says I need you to come in Tuesday and B shift happens to be working, that's mandatory work. It's not necessarily mandatory overtime, it's mandatory work, just
Right.
like Monday. Okay.
Right.
So trying to wrap our heads around what I just said and then apply the FMLA to it, in some ways it simplifies it. And I think that what you can do, and I think I can envision a doctor's note that says that I do not want firefighter Smith working more than 40 hours in a week. Uh, Overtime, undertime, whatever you want to call it, on shift, off shift, scheduled, unscheduled, whatever you want to call it. I don't want him working more than 40 hours a week. I think he can manage his stress with a 40-hour schedule. And we're going to see how that goes. We might have to back it down to 30 hours. Okay. And so on. So I think that's, yeah, I know, but I think that's how the FMLA has to be looked at, and not so much the way firefighters look at it as mandatory overtime versus not versus
Right.
scheduled.
And on the FMLA side, the last thing I'll say before we jump is people shouldn't think it's a permanent benefit. It's not. It's 12 weeks that run concurrent with other time if the employer's written the policy right.
Once it's gone,
It's gone.
no,
So you don't get a 13th week of FMLA if you have a
you can get
if you
pink
have a
slip.
doctor's note.
You don't come to work at the end of those 12 weeks. I
Bye
mean, if you
bye.
use it consecutively, it's bye-bye.
Exactly.
So
Exactly.
yeah,
Well, that was a great bonus we provided to our viewers, but it does allow us to say must
yeah.
have policies, because this is one of the policies you must have. It is a tough one to explain on a half an hour video. It requires more 4 to 6 hours, and we should schedule another FMLA because it's definitely about time.
Yeah. All right. Well, that'll do it for another edition of Fire Law Roundup. We'll see you all next week. And bye-bye from Indianapolis.